Hello, my name's Ingemar Hunnings. I'm lead consultant at Hunnings Consultancy, a management consultancy that does a lot of work with compliance into the legal industry and other businesses. Now, one of the things that we do assist with is data protection compliance, GDPR and such like. And we're recording this chat to talk particularly about the Data Use and Access Bill. We're recording this at the beginning of April. So it's not yet law, but will probably become law soon. And the topic we're looking at is particularly how it affects charities, although this will have wider application than that. So I have with me Samantha Dunwell, who is one of our consultant experts in data protection. And she's also got a particular passion for this area. So welcome, Samantha.
Hi, Ingemar.
Would you like to give us some background to this legislation, when you think it's going to come into effect, what soft opt-ins are, particularly with regard to charities?
Yes, so the Data Use and Access Bill is moving very quickly through Parliament. It is actually expected to be passed either before or shortly after Easter, from what I've read and from what I've heard. So it's very imminent, this new bill. And the bill is going to be making some significant amendments to the Data Protection Act, the UK GDPR, and the Privacy in Electronic Communications regulations. And one of these significant changes is being made to the Privacy in Electronic Communications regulations, and that is to extend the soft opt-in exemption to charities. Now, the soft opt-in is currently only available to us in commercial organisations. Now, the soft opt-in exemption actually has been a topic of debate in the formulation of the various iterations of the data protection bills we've had trying to get through past Parliament over the last couple of years. The previous Conservative government had the Data Protection and Digital Information Bill working its way through Parliament prior to the general election last year, and it did include soft opt-in for charities. But alongside that, it also included political groups being able to undertake their political campaigning using soft opt-in. Now, the Data Protection and Digital Information Bill never got passed because of the calling of the general election. And when the new Labour government came into power, they introduced a different data bill called the Data Use and Access Bill. But when they first introduced that into the House of Lords, they had removed the soft opt-in clause for charities and political groups. Now, at the back end of last year, there was various lobbying that was undertaken by charities and the Data and Marketing Association. And it actually saw the House of Lords reinstate the soft opt-in for charities only and not the political groups. And that's where some of the controversy had laid before in the previous iterations of the data protection bills that were trying to work their way through the Houses of Parliament. So this is now one of the amendments that has actually been accepted into the bill. So we have the soft opt-in exemption being extended to the charity sector.
Okay, and I can understand why the political party side of things was controversial in this me. Can you explain what a soft opt-in actually is in this context, and what is in fact changing for charities?
Yeah, so basically soft opt-in allows any organisation to send direct marketing by electronic means to people with whom they have an existing relationship with. So when we say electronic means, we're talking about things like emails, text messaging, and any other way that you communicate electronically in the digital era with your customers, your members, for example. And the relationship that somebody has with an organisation is usually formed when somebody buys goods or services from that particular organisation. So in a nutshell, it means you don't need to obtain the consent of the person you have that relationship with in order to send them direct marketing by electronic means. Instead, you automatically opt them into your marketing, and in effect, you're actually relying on the GDPR lawful basis of legitimate interest. So, as we said, the current law, it prohibits a charity from using soft opt-in for the purposes of them undertaking their fundraising and promoting their charitable aims. So what the Data Use and Access Bill is doing is allowing charities to take advantage of the same rules that us in the commercial sector have had in place for many years when it comes to sending our marketing by email, for example. So a charity is going to be able to rely on the soft opt-in exemption when somebody supports their cause by either making a donation, if they undertake fundraising for that particular charity, or where they've expressed an interest in that charity's aims, purposes.
Well, that's really interesting. It seems to me crazy that they were excluded to start off with, especially as, well, it's a matter of public policy for a charity. If it's to gain charitable status, it's in the public interest by definition. So why should they be excluded from this? It seems crazy to me. And so people could be supporters of a charity, which then means that they are by definition open to communication from the charity. That sounds like a great idea.
Yeah.
Okay, so how does a charity comply with a soft opt-in? What rules will apply under the GDPR, as people are referring it to?
Yes. Soft opt-in, as usual, isn't as simple as just automatically adding someone to your email marketing. As ever in data protection law, there are some rules that you need to comply with. And a charity is going to have to follow these rules, just as we in the commercial sector have to also comply with these same rules as well. So for a charity, soft opt-in is only going to apply when the sole purpose of that direct marketing is to promote that charity's own charitable purposes. So they can't be promoting anybody else's charitable purpose. It's got to be their own. The contact details were collected when the individual either expressed an interest in that charity's purpose, or they offered or provided support to further that charity's purposes. So, donations, fundraising side of things there. And then finally, that individual must have been given the opportunity to refuse or opt out at the point of their data being collected, and then with every subsequent communication that charity has with that individual. So it's usually like your unsubscribe link that you have at the bottom of your email marketing messages. So these are the same rules that, like I said, that us in the commercial sector have to comply with now. We certainly should be complying with, as we've seen the Information Commissioner's Office does take enforcement action with those organisations that don't comply with these rules. And we have seen some organisations issue with the monetary penalties. But the simple things like failing to offer somebody the opportunity to opt out when they first collect the data. So that's something that a charity is going to have to think about as well.
Yeah, that's really interesting. Clearly worthwhile them getting to grips with. So can you explain what a charity will need to consider when relying on a soft opt-in?
Yeah, so the Information Commissioner's Office has made it very clear that they would expect charities to consider implementation very carefully, and possibly more so than the considerations we in the commercial sector have to think about. An example here is that if a charity decides to rely on soft opt-in, which in effect means that they're relying on the GDPR lawful basis of legitimate interest, they must undertake a legitimate interest assessment to carefully assess their interests and balance them against the impact on that individual's rights and freedoms. And it's going to be very important that a charity does undertake this balancing test, because it's likely that some charities are going to find it is not going to be appropriate to rely on the soft opt-in exemption to add people to their marketing list. And an example that I've got here is that it's if someone was to access a charity's crisis service, such as mental health services, maybe bereavement counselling, it really is not going to be appropriate for that charity then opt that person, a service user in effect, into their email marketing campaigns, because the likelihood could be that it could actually cause some detrimental harm to that person if they knew that they'd approached that charity for some, particularly sensitive reason. And then they suddenly find that they're also then, donate to our charity, undertake fundraising for us. So that's just one of the main things that a charity is going to have to think about. But some other considerations that they're going to have to think as well are around how they're going to make the change from opt-in, which is what they currently have, to opt-out. You can't make any changes retrospectively, so you can't say that anybody who's previously opted in, we're going to change you all to now you're effectively opted out of it, and we're relying on legitimate interest for that. And you need to think about the date that you're going to make that change from as well. So going forward, you've got to decide. It could be, May, June, July, August. It could be next year, for example. But you need to decide on a date when you're going to change from opt-in to opt-out. And they'll have to think as well about the technical capabilities of their CRM systems that they have to manage their marketing lists. Can that CRM system distinguish between those people that opted in under consent and those that opted out, and it's legitimate interest you're relying on? So they might have to think about the technical solutions that they have in place. They'll also have to think about amending the privacy statement. So the wording that is used when they collect the information, again, it's changing opt-in to opt-out. So it's, tick this box if you do not wish to hear from us. And also they'll have to update their full privacy notices as well to reflect that it's legitimate interest lawful basis they're relying on and not consent that they're going to be relying on to collect the data.
Wow. So there's quite a lot to consider there. And it sounds as though this is something that we would need to put a package together to help people on and to help them through. People who are watching this, do contact us because we will be able to help you through this. Just hold your hand, take you through all of these steps, give you a framework, the footsteps to follow through that path to get from where you are now to where you want to be. I can see there's a real gain to be had for this. No, thank you, Sam. A really interesting topic. And because of the speed at which this is working its way through Parliament, actually something that people need to be actively considering.
Yeah.
The legislation, okay, that will come into effect next year or what have you. But it sounds as though this is something that's rattling through to be effective, the other side of Easter by summertime, something like that.
Definitely, yes. Yeah.
So that's really helpful. Thank you so much, Sam. People who are watching, we will be publishing this on YouTube, so please subscribe if you think that's helpful and you want to pick up other things that we publish. We will be putting it out onto LinkedIn and what have you. We help already with other data protection things, and I'll just share my screen so that you can see on our website, Hunnings Consultancy, you can see up here, general data protection support. We do GDPR and data protection training and such likes, and lots of information on here. But if you do want to get in touch, then you can see how you can put in the information. Far better to fill in the form than really me, because I might not be available at that time. But I hope that is an interest and assistance to people. And thank you all for watching.